Why not just have a will for less money? Isn't a will enough to ensure my assets go to my family? What are the risks of my will being contested in court? You most probably have asked questions like this before to yourself, and I'm here to answer them for you. Hi, my name is Seth Levy with Heritance Law, and today we will go over why a will may not be sufficient for you and offer you some alternatives. Let's start with the basics. What is a will? A will is a legal document that states how you want your assets to be distributed after you pass away. It's the most common way people lay out their wishes for things like property, personal belongings, and money. A will can also appoint guardians for minor children, which is a very important responsibility for parents. But while a will might seem like it covers everything, it comes with a few drawbacks, which we'll get into in a moment. The main point here is that a will alone might not be enough to truly protect your estate and your family's interests. One of the biggest drawbacks of a will is that it doesn't avoid probate. Probate is the legal process that your will has to go through to be validated by the court. Probate is time-consuming. It can take months or even years. Expensive. Probate fees, court costs, and attorney's fees can take a significant portion of your estate. And probate is public. Everything in your will becomes a matter of public record, which means anyone can look up what assets you had and who you left them to. So if your goal is to keep things smooth and private for your family, a will in and by itself might fall short. And that's where a trust comes in. So why do you need a trust and not just a will? Unlike a will, a trust can help you avoid probate entirely. A trust allows you to place your assets in the care of a trustee who manages them for your benefit and the benefit of your beneficiaries. This means that your estate can bypass the court process and transfer directly to your heirs much more efficiently. Why is this important? Your assets get to your loved ones faster. There's no need for extra costs involved with probate. It all remains private. Only the people you choose will know what you had and who it went to. Now let me expand on the idea of public versus private in the conversation about a will versus a trust. One of the biggest differences between a will and a trust is privacy. A will is a public document. Once it goes through probate, anyone can look up what you left behind and to whom. For some people, this might not be a concern, but for others who value privacy, this is a significant downside. A trust, on the other hand, is completely private. Your assets and their distribution remain confidential, known only to those directly involved. This can prevent unnecessary attention, disputes, or even opportunistic challenges from people who you don't want to be involved. Now let me touch upon the control and flexibility that you get with a trust. Another key advantage of a trust is the control it gives you. While a will distributes your assets outright after your death, a trust allows you to set the terms and conditions on how and when your assets are distributed. For example, you can distribute assets over time, such as when your beneficiaries reach certain ages. You can set up provisions for multiple generations, ensuring your family is provided for long after you're gone. This kind of flexibility isn't possible with a will alone. Additionally, there are significant protections against challenges that may come, and let me expand on this idea. Another common concern with estate planning is the risk of someone challenging your will. Wills can be contested for various reasons, including claims of undue influence or questions of validity. While it's possible to challenge a trust, it is much more difficult to do so. Trusts are typically seen as more solid legal structures, making it difficult for someone to alter the terms without substantial proof of wrongdoing. Finally, there is the ongoing management if you're incapacitated. A trust also provides for the ongoing management of your assets if you're ever unable to do so yourself. If you become incapacitated due to illness or injury, a successor trustee can step in to manage your finances and make sure your assets are protected and used appropriately. A will only comes into play after your death, so it doesn't help in this kind of situation. Is it worth the money to set up a trust in addition to a will? That's a question only you can decide. But let's recap the benefits. A trust avoids probate, saving time, money, and stress for your loved ones. A trust keeps your estate private, unlike a will, which becomes public. A trust gives you more control over the distribution of your assets, even across multiple generations. Trusts are much harder to challenge than wills. A trust allows for the management of your assets if you become incapacitated. While there is an upfront cost to setting up a trust, it often ends up being far less than what you could lose to probate costs and delays. And when you consider the peace of mind it brings, both for you and your loved ones, the facts often speak for themselves. Ultimately, whether you choose to have just a will or both a will and a trust, the decision is a personal one. But understanding the differences and the benefits of each can help you make the best decision. If you have any questions about setting up a trust or want to learn more, feel free to reach out. Thank you for watching, and remember, planning ahead is one of the most loving things that you can do for those you care about. So click the link below and book a free consultation with us. And together, we can safeguard your legacy.